Hello friends, welcome to UGC EPG Pathshala. I am Suman Dash Vidya-mitra, Assistant Professor of Law at National Law University, Odisha, and today I will be discussing with you a topic titled Victim Witness Programs. Before I begin, let me first introduce the topic to you. Witnesses play a very important role in criminal proceedings. A witness is a person who provides crucial information about the occurrence of a crime to courts. A witness may have first-hand information about a crime, and on other occasions he or she may have watched the commission of the crime by being present on the scene. Since witnesses form such an integral part of a crime scene, their statements are used for the purpose of corroboration as well as for discovering and establishing the guilt of the accused. Their role in establishing the guilt of the accused and in protecting the interest of the prosecution also makes them a very easy target of various crimes. Sometimes they are intimidated by the accused, and on other occasions they are put under massive pressure to retract their statements in courts. As a result, witnesses turn hostile and their credibility becomes questionable. Such hostility of witnesses has deleterious consequences on the prosecution's case and the entire justice delivery mechanism. In this context, witness protection programs become very relevant. So, what is meant by a witness protection program? What are its definitional components and what are the functions of a witness? We will now try to understand these three questions. Broadly, witnesses can belong to two categories: eyewitnesses and circumstantial witnesses. They can be further categorized as prosecution witnesses, defense witnesses, expert witnesses, and then eyewitnesses. Section 118 of the Indian Evidence Act 1872 lays down conditions under which a person is considered to be competent to testify. Under this section, a person can be said to be a competent witness if he or she has the ability and sufficient rationality to comprehend the questions which are put to him, and ordinarily lunatic persons are not considered competent to testify. However, during their lucid intervals, lunatic persons' testimony may be taken into account by courts if courts find that such person is sufficiently capable to understand the nature of questions which are being put to him. Under section 119 of the Act, dumb people can also become competent witnesses. Likewise, children and old or infirm people can also be taken as witnesses, provided they reveal sufficient maturity to understand the nature of questions which are put to them. Prosecution witnesses are such persons who appear on behalf of the prosecution during a criminal proceeding. Likewise, defense witnesses are those who appear on behalf of the accused. An expert witness is not a witness of fact. On the other hand, his or her testimony is scientific and advisory in nature. He or she furnishes data based on special knowledge in a certain area to aid the judge in the formation of an independent opinion. An eyewitness is a person who gives testimony in relation to facts which he or she has seen, and therefore such witnesses play a crucial role in criminal proceedings. When witnesses make statements contrary to the party calling and examining them, they are called hostile witnesses. Hostile witnesses are not considered to be credible witnesses, and their actions suggest their lack of interest in exposing the truth to the court. So, why are we talking about witness protection? And what does the world have to say about witness protection? For this, we need to take a look at the international regime in relation to witness protection. All over the world, various states have adopted laws for protecting witnesses. The growing need for witness protection stems from the fact that the role played by them has a large impact on the conduct of trial or criminal proceeding. Further, witnesses have no stakes in the outcome of a trial as they are neither the victim nor the accused. So, it is the responsibility of states to ensure that they are protected, as otherwise there is no reason why they should appear in court to speak the truth or to help the prosecution while their life and property may be at stake. So, witness protection becomes crucial here. There are a few provisions in various international as well as domestic documents for protecting the witnesses. The UN Convention Against Transnational Organized Crime, or the UNTOC as it is called, under Article 24, as well as the UN Convention Against Corruption, or UNCAC as it is called, under Article 32, make it mandatory for state parties to take necessary measures for effective protection of witnesses. UNCAC makes it necessary for each state party to develop a mechanism within its domestic legal system to protect witnesses, including expert witnesses, from potential retaliation or intimidation. Wherever necessary, states will also be required to protect the family as well as near and dear ones of such witnesses. Since witnesses of organized crimes are always under massive threats of loss of life and property, the UNTOC makes it obligatory for states to maximize witness protection programs. Apart from that, the UNODC also lends support to other states for strengthening their witness protection programs. And this happens by offering technical assistance, which include training and awareness programs for sensitization of judges, police officers and other actors of the criminal justice system. Likewise, it also offers legislative assistance, conducts legal and institutional assessments, and then extends specialized support services to assist in the establishment of witness protection units. Witness protection units are crucial for protection of witnesses. Most importantly, the UNODC plays a pivotal role in strengthening international cooperation for protection of witnesses. In countries, for example, like in Australia, a special law has been formulated which is known as the Witness Protection Act. The law was formulated in 1991 and it exists for protecting the interests of witnesses. Likewise, in the United States of America, the Witness Security Reform Act of 1984 provides for relocation and protection of witnesses in proceedings related to organized criminal activity. Drug trafficking, other serious offences are also brought within its ambit. The final authority to decide whether or not a person may be allowed to enter the witness protection program is the Attorney General of the United States. Three primary organizations play a very important role in maintaining witness protection programs in the United States. They are: number 1, the US Marshal Services, number 2, the US Department of Justice, and then the Federal Bureau of Prisons. The US Marshal Services ensure safety and security of witnesses. The US Department of Justice authorizes admission of witnesses into the program, and the Federal Bureau of Prisons maintains the custody of witnesses who are in prison. In the United Kingdom, the Criminal Justice and Public Order Act was passed in 1994. This act makes provision for punishing those persons who intimidate witnesses. The Director of Prosecutions is in charge of administering the Witness Protection Program in the United Kingdom. Likewise, in Germany, the Witness Protection Act was enacted in 1988. Under this act, the primary focus is on utilization of video technology to examine an endangered witness as well as to completely secure personal information of such witnesses. Now that we took a look at witness protection programs and laws across different countries in the globe, let us take a look at what happens in India in relation to protection of witnesses. Now, the 14th Law Commission report highlighted the problems faced by witnesses in attending criminal proceedings. Likewise, the 154th Law Commission report emphasized on the need for protection of witnesses appearing for the prosecution, as they are always at the risk of incurring injury from accused persons who may be hardcore criminals on most occasions. The Law Commission stated that it is necessary for the central or state government to formulate laws to meet the problems of witnesses. Likewise, the 178th Law Commission report emphasizes that statements of witnesses have to be recorded in the presence of magistrates. Likewise, the 198th report makes provisions for a detailed framework for witness identity and witness protection programs. Indian laws also make some provisions for protection of witnesses. The Code of Criminal Procedure, for instance, makes provisions for in-camera proceedings for some offences. Chapter 9 of the Indian Evidence Act of 1872 contains a plethora of laws relating to witnesses. Section 118 to 134 contain provisions regarding various aspects of witnesses. Section 151, 152 of the Indian Evidence Act protect witnesses from being asked questions which may be scandalous, insulting, annoying, or indecent. Further, the Act also provides that accused persons are restrained to approach witnesses or tamper evidence when released from court on bail. Some special laws like the National Investigation Agency Act of 2008 provide that if the witness or the public prosecutor makes an application on the basis of which the special court is satisfied that the life of such witness is in danger, it may take appropriate measures to keep the identity of such witness a secret. Contravention of such decision shall lead to the imprisonment for a term that may extend to 3 years and may even be accompanied by fine. Apart from these provisions, at various stages of the investigation, the police also has a special role to play in protection of witnesses. Section 309 of CRPC provides that a criminal proceeding must be held expeditiously, and once examination of witnesses commences, it shall be held regularly on a day-to-day basis. To protect witnesses, the manner in which the police conducts investigation is also extremely important, because on the basis of such investigation, charges can be framed effectively, and this can also ensure that the accused does not get away due to lack of evidence or an error of procedure at the time of investigation. At this juncture, let us then try to analyze the structure, method and mechanism of witness protection and assistance. Internationally, there are many provisions related to this, and the structures which have been made keep in mind how witness protection can be maximized and how the identity of witnesses can be protected. The Council of Europe makes a very solid distinction between protection programs and protection measures. So, while the terms appear to be similar in form, the content of the terms is very different. Protection programs refer to those programs which are based on an agreement between the witness and concerned authorities for offering protection to an endangered witness. On the other hand, the term protection measures has a very wide ambit, and it refers to all individual measures that may be taken by concerned authorities for protecting witnesses from intimidation and retaliation. Intimidation and retaliation against witnesses are very common forms of trying to deter witnesses from coming to court, and so the laws make a clear provision in relation to that. So, while protection programs are designed specifically for those witnesses who have an agreement with the appropriate authorities, protection measures are more general in nature and are adopted by actors in the justice delivery mechanism to offer protection to endangered witnesses generally. Witness protection measures as part of a witness protection program and even otherwise are formal processes and must be proportional to the seriousness of the risk faced by a certain witness. Some witness protection measures are relatively very expensive because they form part of witness protection programs. For example, processes like relocating an endangered witness not only involve significant expenses but are also difficult to administer and manage. On the other hand, other formal measures like granting protection to witnesses by appointing police officers, security, etc., they are not only less intrusive, they are also cost effective and easier to implement. Now, these processes or protection measures are viable and safer alternatives to witness protection programs. In many cases, of course, depending on the gravity of the risk faced by a witness. All formal witness protection programs are designated to protect witnesses throughout the period of investigation till the conclusion of the trial. The objective of these programs is not only to safeguard endangered witnesses, but also to ensure that the investigation is fairly conducted without manipulation and the trial proceeds very smoothly. Security of the witness is also a major but not the only concern of a witness protection program. Throughout the program, physical protection of the witness is of utmost concern, and wherever necessary, in many protection programs, the witness is relocated and given a completely new identity. The program also calls for non-disclosure of information regarding the new identity of the witness and limited interaction with the protected witness. However, it must be remembered that although the contribution of the witness is recognized in a criminal proceeding, the idea of a witness protection program is not to reward the witness for supporting a just and cause and aiding the court to complete a fair prosecution. The idea, on the other hand, is to discharge the obligation of safeguarding the life and liberty of the individual who incurred major risks by making statements and offering testimony in a case. An understanding of this aspect is necessary to ensure that not every witness is enrolled in a witness protection program, and only such witnesses are made part of it who are in grave risk owing to the participation in a criminal proceeding. The structure of witness protection programs varies significantly from one country to another. Whereas in many European countries, it is seen as a police function. In other countries, it is seen as a function which is discharged by the judiciary. In Canada, for instance, witness protection program is seen as a police function directly. On the other hand, in the United States of America, it is a function that is discharged by close coordination between three important departments: the U.S. Marshal, the Department of Justice, and the Federal Bureau of Prisons. A study and review of existing structure of witness protection programs reveals that for such programs to retain their efficacy and confidentiality of the highest order, it is necessary that agencies involved in the programs must cooperate strongly with law enforcement agencies. Further, they should operate independently to ensure confidentiality of the witnesses, and therefore they must work at a safe distance from other tiers of the organization. Most importantly, the staff involved in a protection program must not be involved in investigation programs of the case of which the witness is a part. A very significant factor in implementing a strong witness protection program is the adoption of an enabling legislation. The enabling legislation must be a complete legal framework, making exhaustive provisions for formal protection measures and programs. The framework must contain non-invasive provisions like grant of security and police protection to witnesses as alternative measures for other extreme forms of witness protection like relocation and change of identity. Also, such legislation should make provisions to ensure that witnesses do not make use of protection programs to escape civil or criminal liability. Apart from that, the legislation must make provisions for a minimum threshold of eligibility criteria which need to be met before enrolling a witness in a protection program or extending the benefit of protection to him. Further, a yardstick must be evolved to assess the nature of witnesses who would be first in order of preference for receiving protection in a program. For instance, in many countries, witnesses who get precedence for the purpose of protection are persons acting as informers to the police. Since such informers or informants and their handlers are always under serious threat because of the nature of their work and because they play a very important role in reporting crime, they are the ones who are protected first under a witness protection program. A crucial question in witness protection programs is assessment of threat and determination of the need for protection. Without answering this question, any witness protection program will not be deemed to be complete. A crucial factor in every witness protection program, as we discussed, is assessment of threat and determination of the need for protection of witnesses. This goes without saying. So what are the methods of doing it? Laying down parameters is a difficult process. At the same time, this issue needs to be addressed in the enabling legislation for setting up a witness protection program. Since resources for implementing a witness protection program are not unlimited and the costs involved are really high, it is necessary and imperative to assess threat or risk levels to make strategic and optimum utilization of available resources. Before laying down parameters for a threat assessment, it is necessary to understand what contributes to the gravity of a risk. Several factors may go into the making of a threat, but the obvious point of reference is the relationship and proximity of the witness to the accused and the nature of the accused. So, threat assessment may revolve around the assessment of risk posed by the perpetrator for the witness at a certain point of time, as well as the capacity of the police and law enforcement agencies to deal with such threat. However, so far no standard parameters have been laid down for threat assessment in any mechanism of witness protection, and that speaks volumes about the complexity of the problem. At the same time, various countries have tried to address this issue on their own terms. Sometimes, a factor like the lack of identification of the accused or perpetrator is taken as an element to assess risk of the witness. Similarly, nature of the case for which the witness is offering testimony is also taken as a crucial factor for need assessment. So, this is what we discussed, the various points in relation to witness protection programs, which are also associated with the rights of victims. So, as to conclude, witness protection programs bring along a plethora of rights for protected witnesses. But most importantly, they are designed to dilute any risk to the life of a witness. A witness protection program must have an effective governing structure in order to be successful, and the organization of a witness protection program must also be relatively independent so that there is minimum risk of losing secrecy and confidentiality. The judiciary and law enforcement agencies also have a significant role to play in protecting witnesses by deciding the gravity of risk in certain cases and determining whether or not a witness deserves the benefits of a witness protection program. While several countries all over the world have made several efforts for protecting witnesses, in India, this concept is still at a nascent stage. The beginning may be made by adopting a strong enabling legislation that creates an exhaustive framework for protecting witnesses. A positive outcome of this step will be a fair and expeditious disposal of those cases which take years to reach a conclusion only because of a series of witnesses turning hostile. So, to summarize, witness protection programs intend to protect the interests of witnesses who face risks to life or property because of their participation in a criminal proceeding. In India, the Code of Criminal Procedure and the Indian Evidence Act make very limited provisions for protecting the rights and interests of witnesses. Witness protection programs are different from witness protection measures in a very significant way. For a strong witness protection program, it is necessary to have a strong enabling legislation. Before enrolling a witness in a protection program, it is necessary to assess the threat or risk to the life of the witness. A witness protection program, in order to be successful, must have an independent governing mechanism. So, this is what I had to discuss today with you in relation to victim witness protection programs. I hope you learnt well. See you again later. Thank you. Bye.